The biggest story in America today is how many pissed off federal judges there are at Donald Trump and Elon Musk. Welcome back to Democracy Docket. I'm Marc Elias.
And I'm Paige Moskowitz. Let's get started.
Paige, I have never seen as many federal judges as angry with the federal government as there are right now. And there is no judge who is angrier, seemingly, than the chief judge of the Rhode Island District Court, who has issued a blistering order saying essentially that the federal government failed to obey his court's order. And let me just say this: people who disregard federal court orders do so at their peril.
Marc, this is in a lawsuit from 23 Democratic attorneys generals challenging the Trump administration's order to freeze federal grants and funding. Now, this judge in Rhode Island, John McConnell, an Obama appointee, issued a temporary restraining order blocking that freeze. He said that the federal government had to resume payments on all of their programs and grants and loans. The Democratic AGs came back and said, hey, judge, the DOJ and the executive branch is not following your order. And on Monday, the judge issued a new order telling the DOJ that they had to follow his prior order or else.
Yeah, and I want to put up on the screen, we don't usually do this, but I want to put up on the screen the actual language at the beginning of this order. It is a basic proposition that all orders and judgments of courts must be complied with promptly. Persons who make private determinations of the law and refuse to obey an order generally risk criminal contempt, even if the order is ultimately ruled incorrect. Okay, now let me just say, that is the kind of language no lawyer likes to read in an order aimed at them and their clients. But Paige, I have to say, in this instance, it is very well deserved. But a federal judge told all of these federal agencies, told OMB, told the Department of Justice, who are the lawyers for all these agencies, knock it off. Until I rule in this case, there is no freeze in place. And Paige, this has been a game of cat and mouse in which Donald Trump and Elon Musk and Doge and, a whole bunch of people have sort of jumped from agency to agency, and DOJ has jumped from courtroom to courtroom. And in each one, there's kind of like the dog ate my homework excuse from the Department of Justice. Oh, we thought the order said this and we didn't think it said that. And we thought maybe it only applied here, but it didn't apply there. And we have warned, you and I have warned that this day was coming where a federal judge just says they've had enough. And this judge is the one to say, I've had enough. And I got to tell you, Paige, the next step will be either this judge or another judge holding these folks in contempt of court. As this judge said, people don't get to make a private determination as to whether or not to comply with an order. Because even if the Supreme Court or another court later says, you know what, Donald Trump was entitled to do this, OMB was entitled to do this, the fact is they're not entitled to violate a court order in the meantime. And they're going to wind up on the wrong side of a contempt citation. And then we may truly be in the constitutional crisis that so many people are talking about.
Marc, I want to zoom out for a bit. So this is all about the OMB order, which froze trillions of dollars in federal funding. The judge made it very clear that these payments should resume. One of the programs he specifically called out in the order was NIH funding, which after the judge had issued his order saying that the freeze is blocked, payments should resume as normal, you had Doge say that the NIH needs to cut its funding and needs to cut how much money is going out to hospitals. And here the judge said, hey, this looks like a pretty clear violation of my order.
And by the way, Paige, we're focused on this one judge in this one courthouse in Rhode Island. And we are focused on this one case. But if you do zoom out, you see that it is not just one judge who is expressing this frustration. This judge expressed the most frustration in the most florid language. But I want to point out that, in a totally unrelated case in New York City, you had a federal judge issue an order basically blocking any further messing around with the Treasury Department database and accessing it without even giving the Department of Justice lawyers a chance to weigh in. Now, to be clear, that is within the judge's prerogative. There's nothing illegal about that. There's nothing unethical about that. No matter no matter what people on Twitter may think, that is within the judge's prerogative. But that is the kind of action that you are getting from courts who clearly read the newspaper. They read court cases in other courthouses. They see what's coming into their courtrooms, and they've had enough. They've had enough with the willful evasion or the negligent evasion or the left hand not knowing what the right hand is evasion, like whatever it is, they've had enough. And again, this is highly, highly unusual for the Department of Justice of all entities to be facing these setbacks. Paige, one last one. We saw a federal judge in Washington state basically read the Riot Act to the Department of Justice over their arguments around the birthright citizenship. Again, not something one typically sees.
Right, Marc. Then Washington, that was a Reagan appointee who said, quote, "To our president, our law is but an impediment to his policy goals. The rule of law is, to him, something to navigate around or something to ignore. The rule of law is a bright beacon which I intend to follow. I refuse to let that beacon go dark today." So, Marc, let's focus on what's next. The judge said that contempt could follow. Who gets held in contempt? What does that actually mean? How do you actually enforce a court order as the court?
Right. So this is the big question that everybody wants to know, right? Is like what happens here? And I want to start by saying this order from this court is good news for democracy. Like the lecture that the judge in Washington State gave is a good news for democracy. And I see way too many people on the left being cynical and saying, "Oh, but how is this going to get enforced?" Or this is toothless. No, 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 no. So this is the answer to your question. The fact is that federal judges have the inherent power to impose contempt where they believe a court order has been violated. Now, there are some procedural safeguards under many circumstances that people have. They have a right to a hearing. It can't be arbitrarily imposed. But fundamentally, where you have willful conduct to violate a federal court's order, the person responsible for doing that can be and is held in contempt. That can include all kinds of penalties, including in the most severe cases, imprisonment. It can include fines and the like. And the ability of courts to do this, again, irrespective of whether or not the underlying merits were right or wrong, is well established. The language I read and put up on the screen, that is actually from a Supreme Court decision back in 1975. This is not a new principle. This is a well-established principle. And, what I would say to people on the right who may be watching this video and think, "Oh, we don't have to worry about that because, we control the Department of Justice." Federal judges have the authority to appoint private prosecutors to prosecute criminal contempt. So you're not getting out of it quite that simple. And for people on the left who say, "Yeah, but what if Donald Trump just ignores the order, or what if the people in the government ignore the order?" I remind them that Donald Trump may be immune from criminal prosecution, but it is only Donald Trump is. And there are a lot of people, cabinet secretaries, people under the cabinet secretaries, lawyers in the Justice Department and elsewhere, and they do have to worry about the direct consequences of contempt and the indirect consequences of contempt that come with it. So I would advise anyone in the government, do not test the patience of these federal judges. Do not think that you are going to win a battle with a federal judge over whether or not to comply with their order. And so this judge in Rhode Island is being very judicial, which is good, right? You want that from a judge. He's being very even-tempered. He has now issued an order. He issued another order. He's issued this order, which is like hey, you haven't been paying attention and paying to my prior orders, and you do so at your peril. And hopefully now it de-escalates from there.
Marc, the judge this week said in his order that the defendants must immediately restore frozen funding while the TRO is in effect until the court hears and decides the preliminary injunction request. So, Marc, two questions. One, what the hell does all that mean for everyone who's not a lawyer? And two, the DOJ is appealing the original order, the original TRO, and this order to enforce. So what happens in the meantime?
Okay, so think of a TRO, a temporary restraining order, as the house is burning right now. I need people to pour water on it right now. Okay. TROs are when there is an absolute emergency and there's just not a lot of time to figure out what happened. A preliminary injunction is there are sparks in dry hay that is stored outside the barn by the house, right? It's pretty urgent, but it's not like on fire right now. And then when we talk about the merits, that is, hey, the wiring is faulty and it may cause a fire someday. So when you have cases like this, oftentimes you will see an immediate request for an immediate halt, a temporary restraining order. Those usually are only in effect for a matter of days until the court can take a breath, read all the pleadings, maybe hear some evidence, and then there is then a hearing. So TRO is like, a matter of days. Preliminary injunction puts things in hold or puts in place interim relief for what can be months or longer. And then a final decision on the merits that can come after a full trial, and that can take obviously much longer. Now, it is not unusual for preliminary injunctions to be appealed because they have such a long time period. It is really unusual, I won't say unheard of, but quite unusual for a court of appeals to hear an appeal in a temporary restraining order, because honestly, by the time the Court of Appeals is even considering the temporary restraining order, it's usually already either been turned into a preliminary injunction or it's been denied. Like, the temporary restraining orders happen so fast and they're either replaced by injunctions or they're not. I wouldn't expect anything to happen with respect to the appeal of a TRO. I think that's a little bit more of a PR stunt. I do think that the cases will proceed on the preliminary injunction route, including to the Court of Appeals. But I want to again say it is not a defense to contempt. It is not a defense to failing to comply with a court order that you ultimately won because a Court of Appeals said that there should not have been an injunction. Contempt is about vindicating the right of the court to issue these orders. And so to the extent that there are efforts by people on the right to disregard them, they do so at their peril. But we will see. Democracy Docket is covering day in and day out all of the news around all of these lawsuits involving Trump accountability and whether or not the Department of Justice is going to abide by rule of law, whether they're making accurate representations to courts, a whole other video we could do with the various corrections they've had to do. But please make sure you are subscribed to Democracy Docket's free daily and weekly newsletters, because it is a vital source of accurate, timely information about all of these important fights that are taking place. Thanks for joining us.